everyone, you're watching News Epicenter with me, Maria Shakil. In a landmark verdict, the Madras High Court has ruled that it is open for a Muslim woman to exercise her inalienable right to dissolve a marriage by Khula, which are divorce proceedings initiated by a wife, by approaching a family court and not private bodies such as a Sharia council. The High Court ruled that private bodies cannot pronounce or certify the dissolution of a marriage by Khula as they are not courts or arbitrators of disputes. The court ruled on a writ petition by a man who sought the quashing of a Khula certificate issued to his wife in 2017 by a Sharia council. The court ruled that Khula certificates issued by private entities are invalid. It directed the petitioner that his wife should approach the Tamil Nadu Legal Services Authority or a family court to resolve their disputes. Now, many activists have hailed the move, calling it a push towards legal uniformity and a blow to regressive personal laws. First, let me explain to you what Khula is. It is the process where a wife initiates divorce proceedings in Muslim marriages. Wife needs to list reasons in a form to the Sharia council as to why she wants divorce from her partner or husband. Council then holds mediation between these two parties, tries to ensure that they can come together on the talking table. Both parties, that is the husband and the wife, have an option of receiving marital counseling. Joint meeting allows parties to air grievances and identify issues, and then talks on terms of separation on failure to reach a resolution. And if husband consents, then Sharia council issues a divorce certificate. Remember, this is a right which is with a Muslim woman, that she can take Khula or go in for separation from her husband. But if the husband refuses, then Sharia council issues maximum of 4 notices. And if no resolution after 4 notices, then council issues divorce certificate. Now, many argue that the Madras High Court verdict perhaps has opened a Pandora's box. Why are we saying that? First, it has set precedent of holding Sharia council invalid. What happens to all the other decisions of inheritance, marriage, and other decisions that are taken by Sharia council? And decisions by Muslim bodies can be overturned by laws. So personal laws versus the law of the land. That's what we are seeing here. But there is also equality for both men and women in eyes of the law. Perhaps that is what is needed at this hour. And sets stage for debate on need for a uniform law. Is there a need for a uniform civil code? Perhaps increasingly we realize, yes, it is. However, there has been a consistent legal conundrum over personal laws. And this is what the Kerala High Court ruled in October 2022. Because there has been a series of verdicts by multiple courts of India where we see that the personal laws have been overruled by the court of the day. Why and what does it, where is it all heading? Let's not forget what the Kerala High Court ruled in October 2022, where it said that marriage with minor Muslim girls violates POCSO, and rightly so, it does. But the same court also ruled in 2022 that Khula, that the decision of a Muslim woman to separate from her husband, is absolute and not subject to her husband's will. That is what also Sharia says. And the Karnataka High Court, that was what the Kerala High Court had said. We are looking at the Karnataka High Court judgment, which in October 2022 annulled a pregnant Muslim minor's marriage. It ruled that POCSO overrides personal laws. But in October 2022, there is another court. This is Punjab and Haryana High Court, which ruled that on turning 15, Muslim girls can marry whoever they choose. 15, that age 15. What is the age in India? Very different from this one. In fact, the Delhi High Court in August 2022 ruled that a minor girl who attains puberty can marry without parental consent under Muslim laws. So a legal consensus on the issue is still missing when it comes to a debate between personal laws and uniform laws. The question then remains, can there be a balance? Joining me on the show, Geeta Luthra, Senior Advocate of the Supreme Court. We have Rahul Ishwar, author and activist. Atiq Ur Rehman, Islamic scholar. Ahmad Ayaz, former Secretary of All India Muslim Personal Law Board. Also, Zeenat Ali, Director General of Wisdom Foundation. Zeenat Ali, increasingly we are seeing courts entering into domain of personal laws. If you look at multiple verdicts that have come from multiple courts, they are clearly saying that personal laws are not keeping pace with changing times, and hence the law of the land must prevail.
I think, thank you for inviting me to the show, and I think that this particular judgment that has come has to be extremely welcomed, and it is a very important judgment that has to be looked into. And when we say that the courts have intervened, they have intervened because the Muslim women have gone to the courts and have sought justice. If you look at Sharia Banu, if you look at right down from Sharia Banu to Sharia Banu and the other cases, it is Muslim women who have approached courts for justice, and it is the courts that have given Muslim women justice. As a matter of fact, the very commendable judgment that was given by the Kerala High Court, as far as the right of the Muslim woman to Khula is concerned, were never really established by the Sharia law as they should have been. It actually was the right of the Sharia court to establish that a woman had the absolute right to divorce her husband. When we had the two very clear cases that have been quoted of Baria and of Jamila, who had approached the Prophet. As a matter of fact, Baria was a lady who wanted to divorce her husband, and her husband loved her, and he used to follow her in the streets of Medina. This is what the hadith is saying, with tears in his eyes. But when she said she wanted a divorce, the Prophet granted it to her, and therefore the Kerala High Court very correctly ruled that it is the right of the Muslim woman to, not to ask or to beg or to plead, but to get a divorce on equal grounds because she's an equal partner in a marriage.
Okay.
And so
I can see Geeta Luthra as well. Geeta Luthra, increasingly, if you look at the Kerala High Court, which has, of course, passed this judgment this time around, multiple orders of 1 of November 2022, which has actually said that POCSO Act overrides Muslim personal law. Kerala High Court October 2022 judgment that Khula is absolute and not subject to husband's will. This is also what the Sharia says. Karnataka High Court judgment, and increasingly we are seeing some kind of back and forth which is happening between personal laws and the law of the land. Many would say that this is a fit case for Uniform Civil Code.
So, of course, see, there are aspects of Uniform Civil Code that are important. I, for one, have always been saying that for certain common parameters, there should be a Uniform Civil Code. For example, right to inheritance with regard to, for women as well as men, it can't be unequal. It can't be unequal if you want a divorce. Now, there are aspects. In Hindu law, for example, marriage is sacred. It's considered non-contractual. In Muslim law, it is contractual. So there will be certain parameters which may reflect the religious ethos. But the question of equality is something which the Uniform Civil Code will address, and that's why it's very important.
Okay. Ma'am, you make that question of uniformity or gender equality, because, if in this particular case, many would see this, if the woman has taken a call unilaterally and gone in for Khula, then why should her, right given by Islam be not seen as acceptable to the court? And in the court, why should she go through the entire process and her marriage be contested when she has taken a decision of walking out of that marriage? My question then to you, Atiq Ur Rehman, would be that Sharia was never frozen. Sharia was also supposed to change with changing times. Do you think that has become a problem, and that is the reason why we are seeing increasingly, triple talaq? What has happened with triple talaq? It was declared null and void only because Muslim Personal Law Board and the Muslim bodies in India did not realize that for a modern society such as ours, for a democracy such as ours, it was not needed.
Yeah.
Fine, Maria, you see, the only reason...
Ji, Atiq Ur Rehman sahab, go ahead.
The only reason I find for the survival of the Sharia courts is the tedious process our constitutional courts are having and the long amount of pendency. Otherwise, as far as I have observed in our society, none of the Muslims want eagerly that their disputes should be settled by the Sharia courts. Primarily, I am of the opinion that we are not hoping for any justice in the Sharia court. The Sharia court is only for an amicable solution or a rapprochement between the two families or the husband and the wife. Otherwise, we are not expecting any justice. Justice can only be delivered by a constitutional court. Okay. And for this particular
but
case,
then why are you saying, Atiq Saab, that it has become irrelevant? Because you are essentially saying that these courts, the Shariat councils, are irrelevant now.
As far as the cities are concerned, Maria, there are no Sharia courts. Some organizations, they organize, some mufti is sitting over there and they call for disputes. And very unwillingly people go over there. This is my observation. Even if willingly they are going there, justice cannot be expected in a Sharia court. Because only the purpose of the Sharia court, Maria, is for a rapprochement process between the husband and the wife. They want to save the marriage. And if there is a dispute, the mufti says the husband is right and the wife is wrong, they are open to go to the constitutional courts. They cannot be compelled to stick to the mufti's argument or the ruling. This is a general perspective of a Sharia court.
So you are saying that Shariat courts have this attitude, Ahmad Ayaz, according to Atiq Ur Rehman, and I tend to agree with him on this, that they are looking for reproachment. But if a wife has made up her mind and she is looking for a solution, then should she approach a court of this nature? Because if anything, even in this particular case, the husband has challenged it through the writ petition.
You see, as it is in every religious, they have their personal, what you call it, laws. So likewise, though I am not aware about how it works in with other religion, but so far as Islam is concerned, it has a set procedure, a well laid down procedure as to how to deal an issue and well defined and clear cut procedures given for everything, not only in case of marriages, divorces, law, inheritances, everything it's laid down. But the point is how well read is a Muslim to see that he applies all the rules of its own. Well, that being perhaps a difficulty. Otherwise, if Muslims are well read about it, and I don't think they would need any second or third person to go about and seek their advice.
Point that is being made here, Ahmad Ayaz, that bodies such as Muslim Personal Law Board here in India, which was so far seen as custodians of the Muslim laws, or the laws that are governing the Muslims all over the world, particularly in India. Let's look at India specific. Those bodies are becoming inconsequential.
It is not the Muslim Personal Boards. No, it is not the Muslim Personal Boards which are the custodian of the laws. The laws are for every individual. So far as personal laws are concerned, those are for every individual. Now what happens in the process, sometime when there are difficulties arising between the community on various issues, then of course the Maulanas, Muftis, whatever.
But that is subject to interpretation.
Whatever is available.
But that is subject to interpretation. What we are seeing.
Not interpretation.
No, that is subject to interpretation. Let me give you a small example. What we have seen as far as inheritance is concerned, we know what is the division between a girl child and a male child in Islam. But when it is just one boy and a son, a boy and a girl, then how do you distribute the wealth between the two of them? So that is also subject of interpretation. Whether it
that also is well defined.
It's not
defined.
No,
sorry, Shakil, that also is well defined. That also is well defined. What should be the part of the girl or what should
Ahmad
be part
Ayaz
of the boy.
We know what
that
is happening across India.
What is happening
How
is different.
Inheritance
What is happening
in
is
the
different.
Name of,
wait.
In the name of passing legacy to your child, to a son, how women do not have right over inheritance. We have seen what is happening. I've seen it within my own community and within my own relatives. So let's not put this charade that the book is being followed here. One moment. Rahul Ishwar.
Maria, that
No, Rahul Ishwar. No, you are making a problematic argument.
Just two submissions. One, there are 2 or 3 critical positions regarding uniformity. One is a liberal position, let us say, which says homogenize. Generally, nationalists also agree with it. There is a conservative position which says, let nobody touch our religion. That can be in every community. Then there is a centrist approach like RSS Sarsang Chalak, Guruji Golwalkar, who says, let reform come from within. These are broadly the 3 parameters or paradigms in which the personal laws are generally seen in India. So there is always, for example, the Law Commission under Modi government itself said there is no need for a uniform civil code. That's a perspective. But there are many people who actively vouch for a uniform civil code. But here there are 2 or 3 questions. How can we reconcile religious laws with a modern government or a modern democratic nation is one question. Second, no religion should feel violated. No religion should feel invaded. No religion should feel any kind of invasion from the secular government. So we need to keep some kind of a balance. Maintaining that balance is very critical to the uniform civil code debate. Let us have diversity, but let us have some common ground.
Are you then saying that there is more, tinkering or invasion, the word that you used, largely with Muslim personal laws? Rahul?
I mean, any law for that matter. See, I'm a conservative Hindu. I understand the sentiments of our Muslim brothers. I myself is a conservative person, so I can respect and understand. But at the same point of time, we need some common ground so that we all agree on. We need some kind of commonality and agreement and harmony, that without invading. So it's a very tricky question. Baba Sahib Ambedkar grappled with it. Nehruji grappled with it. There are various thinkers, even in the Constituent Assembly debates. Our Muslim brothers were seeking some kind of an assurance that it will not violate Article 25 or what is presently Article 25, the right to faith. So it's a tricky question, but just one submission. It would be unfair for our courts to apply POCSO and punish those people, because these youngsters who are going to get married are doing so under the will and wish of their parents. So there is no point in punishing a guy who has married.
They should be punished. No, Rahul, I'm in complete disagreement with you. These parents should be punished under POCSO if they do not realize that their children are not ready for this kind of arrangement. That a marriage, which Muslim marriage, which is supposed to be contractual, should not be entered in. Let's not forget what Sharia says. No. Quran is very clear. It says that both the man and the woman should be aware of their rights in this contract. Muslim marriage is a contract between 2 individuals who understand the ramifications of this contract. Geeta Luthra?
What, Ishwar? Should I?
Yeah.
Yes.
So, I would like to respond to Ishwar.
So, of course, in answer to what has been just said, should it be punishable under POCSO when, in fact, their personal law permits it? This is a very vexed question. In fact, on behalf of National Commission of Women, we've gone to the Supreme Court in this. There is yet one other writ petition which has been, SLP, which has been filed, both against the Punjab-Haryana judgment as well as the Delhi judgment. Now the issue then is, if somebody does something innocently, should they get bail? They are not talking in terms of is it illegal, should they be punished under POCSO, not punished, because unless you are raising awareness that this becomes a POCSO offense, people are going for it because they are feeling the Muslim personal law is there. But POCSO will override that Muslim personal law. So, as a result, I think people need to be educated, people need to be made aware that they may not be incurring criminal liability, which is a very strict criminal liability under POCSO, if they don't realize that these
Yes.
penal laws
Ma'am,
are
you're making that point.
having
Then-
a precedence. Yes.
Yes, because you are saying that these laws have precedent over. Complete your point, ma'am.
So over personal laws.
Okay.
So I'm just saying that POCSO will have precedence over personal laws, and because there is it's a later enactment. It is also codified because they are trying to ensure that a child, whether man, whether girl or boy, is not abused, even if it is with consent of elders or whatever. So unless you educate people that they realize that what they are doing is wrong,
Okay.
and that
Since you are saying that there has to be a
part
need,
of the
there is a
issue
need for
that is
generating
being
awareness. That is the reason why I want to understand from you, Ahmad Ayaz. It's very clear that private bodies such as Sharia Council can now pronounce or certify dissolution of marriage by Khula. That is what the Kerala High Court verdict is. Increasingly, we are seeing, be it that POCSO Act overrides Muslim Personal Law Board and Muslim Personal Law, and rightly so. If you marry a minor, and that is the way it should be, then my question is, shouldn't All India Muslim Personal Law Board and all such bodies be open to changes? Why don't you take the first step in dissolving these?
No, I tell you, no, that's what I was going to tell you, that Muslim bodies are not themselves to interpret certain things. The Quran itself is very clear about as to how to deal the issues as are confronting, like the divorces and inheritances, laws of India. All this is very clear. The point is that the Muslims themselves need to be acquainted with the laws. They need to be acquainted with the Quran itself, so that then they may not need
No,
to
but what about
seek interference from anybody.
that a girl,
sometimes-
if she attains puberty, should be married off? It was said and written at a time which was very different. Centuries ago.
No, that's what I'm telling you, that as long as Muslims are well versed about the Quran and the Islam, then situations will not arise like this.
I'm
now,
not
why
too sure it is
situations,
about being well versed.
arise
Atiq Ur
because-
Rehman, 30 seconds to you, and then the final words to, I'll give the final word to Zeenat Shaukat Ali.
Yeah. No, Maria, justice and equality was the way of the Prophet. When a very pertinent question of Khula came before the Prophet asked the wife who was seeking Khula that, are you ready to give back all the gifts your husband had, showered upon you? She said, yes, I am ready to give. Equality is maintained. If there are no reproachment between the couple, the equality aspect cannot be hidden by any minority rights. Article 25. We are a patriarchal and a misogynist society. Then the legal courts are only the last refuge of a woman.
Absolutely,
If
Atiq
you
Ur Rehman,
violate
I'm
the rights
glad
of
that
the
you have
woman,
made this
she is
point
bound
that
to go
Muslim
to the open
society
court.
increasingly is patriarchal and anti-women. Let's be clear about it. There's no doubt, absolutely. Yes, Zeenat Shaukat Ali.
Yeah, what I need to say is that you see the main contention and the basis of the Quran is adl or justice, which has never been implemented. The triple talaq has never been part of the Quran, and yet it has been a practice law for 75 years in this country till we had to fight to overcome it. And who did it? It was the secular courts, and it was the Muslim women who went to the secular courts. So let's be very, very clear on these aspects that, no courts are looking for anything but justice. And so minor marriages are also not permissible. All over the world, these changes have taken place, and they have taken place by the, by the action, by the understanding of the Sharia. The second thing that I need to say, as far as the Uniform Civil Code is concerned, we keep bringing these impediments in the way. But if you look at, I think it was the year 1860 when when the British were making a uniform criminal law, and when the laws were laid down, there was absolutely no objection. Criminal laws
from civil
were made
perspective are different.
criminal laws were made practical for practice for all religions, and today there was no hue and cry created about it because the ends of it was justice. So
No, but is
similarly
this
today,
justice?
I don't see
Is
why we-
equality justice? Certainly it is, and it may seem, as far as gender argument would be, that if woman has gone for khula, why should she be approaching the law of the land or the court of India for justice? But then in the long run, it should be seen from the point of view that this is law over gender, but you are equal in the larger eye of the law, which is certainly a welcome move. Geeta Luthra, always a pleasure to have you on my shows, ma'am. Rahul Ishwar, Atiq Ur Rehman, Ahmad Ayaz and Zeenat S Ali, thank you so much. There's a